all persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and His honorable court. This honorable court is now in session. Please come to order.
Good morning. Welcome to a virtual oral argument before the District of Columbia Court of Appeals. We are here with the parties on Zoom and we are streaming live on YouTube. We hope that we will not encounter any technical difficulties, but if we do, please bear with us and we'll sort things out. We have 3 cases on our calendar today, and I would ask that the parties introduce themselves for the record and for appellants to let us know how much time they'd like to have for rebuttal. The first case is Eugene Hickerson versus the United States, case number 17-CO-1443. So, counsel, when you are ready.
Thank you, Your Honors. Good morning. My name is Patricia Cresta Savage. I am counsel for the appellant, Eugene Hickerson. I reserve 5 minutes for my rebuttal. On behalf of Mr. Hickerson, I would like to begin with a short synopsis of the facts leading up to this appeal. In 1976, Mr. Hickerson, a teenager, pled guilty to a sex offense. In 1977, he was sentenced under the Federal Youth Corrections Act into AG supervision under 18 U.S.C. 1510B for up to 6 years. In 1977, he went to Lorton for detention for a little over a year and then was released for into a halfway house for 3 months. No proof exists whether the set-aside certificate was or was not issued. From 1978 to 2021, about over 40 years, he has never had another sex offense arrest or conviction. As the court is aware, in 1999 and 2000, DC SORA enacted their registration requirement 22 years after his conviction. In 2016, he pled guilty to misdemeanor drug possession and served probation with mental health court and was monitored by CSOSA. 2017, CSOSA gave him notice he had to register under SORA, at which point counsel asked for judicial review of the registration requirement, which was denied. In 2019, the judge denied reconsideration and this appeal follows. On behalf of...
So we're familiar with these facts, and it's apparent that there was a lot of litigation about who had the burden of proof to establish that that your client was unconditionally discharged and that his conviction was set aside under the FYCA. But I'm wondering why it matters. The SORA statute says that anyone with a registration offense has to register as a sex offender, and there's no dispute that your client's offense from 1977 was a registration offense. The only carve out for registration is if a conviction has been reversed or vacated, or if the person has been pardoned for the offense on the ground of innocence. And even if your client's conviction had been set aside under the FYCA, it seems to me that that set aside is in the nature of a pardon on the basis of rehabilitation. And it's not a pardon on the ground of innocence. And so it seems like the plain language of the statute just does not permit the relief that you are arguing your client is entitled to.
Thank you, Your Honor. In response to that, I would argue that it is our purpose to determine that the clear legislative intent of the DC SORA 1999 is to protect the public and prevent sex offender recidivism. but it is in direct conflict with the FYCA, which, as the court mentioned, has a rehabilitative purpose. But in addition to that rehabilitative purpose, it's to ensure that the conviction is out of public view.
I mean, I would think, counsel, if there's a conflict between these two statutes, and I'm not sure there is, there's a conflict. No, the legislature is free to change its mind, and it's the later enactment that would control.
I would argue that's exactly right. There is a conflict because the DC SORA, its intent, and as the court knows, the requirements to register have become much more stringent since he was convicted, and even since 2004, because people have to sign up for the internet, and they have to register, and it's out there in the public view. Whereas under FYCA, the set aside is just what it sounds like. It's to keep it from public view, and the only time it can be referenced is through the court. So that's where the conflict lies.
Counsel, I might agree with you that the set aside under the FYCA was envisioned as something much more robust than what the evolution of the case law led us to, right? So, 1964 in Tatum, the DC Circuit, in a precedential opinion is saying, the set aside appears to provide greater relief than a presidential pardon, right? It expunges the conviction and releases the offender from all disabilities imposed by the offense and restores him to all of his civil rights, right? That's broad, that's powerful. Nonetheless, as Judge Deal said, in 2000, our council passed the SORA statute, recognizing that, there were still people out there in the world who had FYCA convictions. And the council decided only to carve out from registration people whose convictions had been reversed, vacated, or pardoned on the ground of innocence. And I given that policy decision, I'm not sure what we can do as a court.
Well, I think this court, in looking at that, I don't think the legislative intent is expressly, as the government argued on page 26 in their brief, that the legislative intent of SORA was to make sure that persons whose conviction had been set aside under FYCA, that it applied to them.
Well,
the court is aware FYCA is defunct.
Excuse me. So the first rule of statutory interpretation is the plain language. And I hear you talking about legislative intent. Are you saying that the plain language is ambiguous? Are you saying that we should look somewhere else beyond the plain language? I'm trying to understand what your argument is under the SORA statute.
What I'm saying is, yes, you have to look somewhere other than just the plain language. And I would argue what I would argue, Your Honor, is that in this case, where it defeats the purpose of the statute to say that he's a public safety issue and that he is a recidivist.
Let me interrupt you there and say that the SORA statute was passed, I think, expressly stating we're not concerned with individualized assessments of dangerousness. That's not what this is about.
And Ms. Cresta-Savage, I guess the question that my colleague asked initially is one that still troubles me, and that you say, yes, we should look beyond the plain language, but you haven't indicated in any way that the language itself is somewhat ambiguous. It's pretty clear exactly what those exceptions are to the SORA registration requirements as outlined in the Act.
Well, And then I would, there is a second issue in this case, Your Honors, and that is the fact that in 2004 in Ray WM, it was decided that the statute is not punitive, but I would argue that much has happened since then. And as it applies to this case under Doe versus Webster and the Mendoza-Martinez factors, that Mr. Hickerson, who has been sex offense free since 1976, is not the type of individual that the SOAR Act should apply to, because of the fact that he is not a threat to public safety. So as applied to this case, this is, I would argue, an as applied case and not based on the literal meaning. And I would argue that the intent of SORA should not cover or apply to Mr. Hickerson, because it violates his constitutional rights and because it violates, because it, I think, is not in keeping with the public safety requirement of SORA.
So counsel, you said, much has changed. I mean, you recognize that this court in Ray WM rejected the constitutional claims that you were raising in this case, and we are bound by that decision. But you were making the argument that we should not be bound because it's different circumstances now in 2021. I'm not quite understanding what you think the different circumstances are. I heard you say something about the internet registration, or dissemination of information on the internet is referenced in Ray WM. So I'd like to hear a little bit more about what you think has materially changed such that we would be able to say that Ray WM is not controlling.
Yes, in Ray WM, as the court knows, was decided in 2004. Since that time, if I may, there have been many other states who have looked at the statute and its application and have applied it. The state of New Hampshire, Maryland, Oklahoma have all determined that it was punitive based on their state constitution. Now, I understand in DC, there is no state constitution, but recently a decision in the Sixth Circuit in Tennessee, as recent as February 21st, 2021, it goes through specifically what all the punitive measures of sex offender registrations are, including not only public internet, but private internet, HUD regulations, employment issues, the fact that the individual has to be evaluated every month and has reporting requirements. Mr. Hickerson, who for 43 years has not had to register, is now forced to register for life. And despite the fact he was a youth offender.
Counsel, excuse me. How is that different than the requirements that were imposed or that were upheld in Ray WM, right? I mean, lifetime registration was a consequence that was reviewed in Ray WM.
But these circumstances, again, as applied to this case, are different because of the Federal Youth Corrections Act. And again, getting back to my original point, I think the two collide. And so that's how this case is different. I think in Ray WM, the Federal Youth Corrections Act did not apply. And again, just briefly, the fact that we don't have the set-aside certificates, and I know this court does really not want to address that, but the court will recall that under the 1997 National Capitalization Act, they closed Lorton, the Board of Parole changed, the U.S. Parole Commission is now supervising people, and which is why we can't find this certificate. But nonetheless, I think it is contrary to the purpose of the FYCA that, and the Mendoza-Martinez factors, and there are 7 of them, you know, I think the most important ones are 1, 4, and 7, which is whether the sanction involves an affirmative disability or restraint, whether its operation will promote the traditional aims of punishment, retribution, and deterrence, and whether it appears excessive in relation to the alternative purpose assigned. I would argue that this is excessive because Mr. Hickerson has been 43 years with no additional sex offense crimes. He is not a danger to public safety. He has proven that. And therefore,
Counsel, it just sounds like an argument for the en banc court to me, given what our precedents say. But I did want, while I still have you, I know your time is winding down. Could you just answer one question for me? He pled guilty to misdemeanor possession. Is that right?
that's correct.
And I assume nobody, not defense counsel. I mean, let me know if the record doesn't tell us. I just haven't seen. Not defense counsel, not the court, not the government informed him that this was one possible consequence of his guilty plea, right?
Correct, because at the time he pled guilty to a registrable offense. I mean, an unregistrable offense.
Right. And nobody said, hey, this thing that you have from 1976, that could be trouble. All right, I asked because I know this is not the claim before us.
No, but I think that's an excellent point because it wasn't perceived as a collateral consequence or even a direct consequence at that time.
Well, I'm more just going to whether or not this was a knowing and voluntary plea and whether or not he received effective advice on his plea. But those aren't the claims before us. I'm just curious what the record reflects on that.
Just briefly, it was several months after he had entered the plea and after he was being reviewed by mental health court that we learned.
And so no motion to withdraw the plea at that time?
No motion to withdraw the plea.
All right.
Thank you, counsel. We'll hear now
Thank you, Your Honors.
from Mr. Carroll. If you could mute your mic. Thank you.
Thank you, Your Honor. May it please the court. My name is Ethan Carroll, and I represent the United States. I think I'll start by just addressing the last point that was, well, not the last point, but the constitutional claim that appellant is raising. And I would just point out that, unless I guess in the Sixth Circuit case that is cited in appellant's reply brief, that mentions the factors that have changed, and then also the increasing punitive nature of the SORA like statute that was being reviewed there. That was a statute that actually imposed restrictions on where sex offenders could live and travel. And so is just completely different than the statute here, which doesn't impose any of the same kinds of affirmative restrictions on where someone can live, travel, work.
Is our statute pretty much analogous to the Alaska statute that was at issue in Smith v. Doe?
It is, and that's what this court said in WM, the 2004 case that Your Honor has referenced several times. I've gone and checked the SORA statute, and there haven't been any changes that increased its punitive nature since 2004. There have actually only been two changes. The first of them has to do with the definition of registration in the context of pandering, which doesn't have any applicability to this case. And then the second of which was there's a stylistic change in 2013, and then also it actually lowered the amount of a fine for a subsequent conviction for a criminal violation of SORA. So if anything, the statute's gotten less punitive since 2004 and not more. So there's nothing.
Could you just explain to me for a second what sense there is behind the statute now? We have the statute that we have, so I'll grant you that. But what is the reasoning behind SORA's requirements applying only prospectively, except if somebody finds themselves back in custody? Mr. Hickerson was apparently, in the council's judgment, it was totally fine for him not to have to register from 1999 to 2017. And then suddenly, because of a misdemeanor heroin charge, that calculus has changed. What sense does that make? So
this court, I think, has addressed that in the 1987 case, Barnes versus the United States, which is cited in our brief, where it indicated that the rehabilitative reasons for preventing dissemination would ring hollow following a subsequent conviction. So I think it is that the rehabilitative reasons that existed back in 1977, when Mr. Hickerson was convicted, just don't go as far given his subsequent convictions. And someone who, so put
No, I'm
otherwise,
sorry. Put the Youth Act totally aside.
Yeah.
Like, let's say he wasn't a youth. Let's say he was 40 years old when this happened. SORA still wouldn't require him to register because it applies only prospectively unless somebody comes back into custody. Like that's the thing that I just have a hard time understanding why the council would have, you would think they might say it applies to everybody, no matter when their offense was, or it applies only prospectively. But to apply it retroactively, but only to the subset of people that later come into custody on anything, I just don't get it. And I was wondering if there is some rationale behind it that I don't understand.
I mean, I can't speak for the legislature's intent beyond.
I'll take any rationale.
And I do think that I mean, the lack of rehabilitation. So if someone has come back into custody, then it does appear that they're still a danger. So, we should make sure to publicize this prior offense. And then I guess the one that is perhaps a bit more of an imperative is the council's concern with the actual facts, what actually happened, and whether someone is a danger. So throughout the legislative history of
but
SORA,
really, I mean, let me just interject. I mean, that strains it strains rationality pretty quickly, right? I mean, a drug offense, or say, a fraud offense, right? The danger that we're talking about, that supposedly SORA is supposed to give the public information to help themselves guard against, we're talking about just apples and oranges, and it really doesn't seem to make any sense whatsoever to have this regime. I mean, granted, it seems to be what the plain language compels, but.
Sure. I mean, we have the statute we have. This court in WM indicated that, rational basis review was easily satisfied on these facts. And I would, sorry, Judge Washington.
Well, go ahead and finish your thought.
Okay. And I guess I wouldn't necessarily agree that there isn't a connection. For someone who kidnapped and sodomized a 10-year-old, we should be concerned with the fact that he's now violating the law again. We should be concerned about the fact that he isn't rehabilitated and appears to, have a number of convictions from more recently. That is a real concern.
Mr. Carroll, going back to, because you raised, of course, WM, and WM relied in large part on Smith v. Doe, and what Ms. Cresta-Savage seems to be arguing to us here, although we cannot go back, as my colleagues have said, and overrule WM, the Alaska statute that Judge Easterly asked you about is one that didn't have a notification system, no in-person reporting requirement, and so without the active notification system that somebody's a Class A offender. All those things are different than they were in Smith v. Doe that we relied on in WM. And recently, or more recently, in Michigan, the statute that had some of those requirements was found unconstitutional in Doe v. Snyder. WM still binds us, but doesn't the sort of statute similarity to Michigan in terms of registration requirements suggest that perhaps the council, if not this court, or let me ask you this way, in a different way, can we look at that statute in Michigan and analogize it to ours as a way of determining whether, in fact, the registration requirements in this case, are constitutional be in an environment other than an en banc court?
No, they are completely different. The crucial factor in Snyder were the restrictions on where someone could live and work. There's a map in that case that actually shows the areas of the state where a sex offender is prohibited from even loitering, and it carves out a huge chunk of the state. And that was the determinative factor in Snyder, not the more active notification that may be similar between the Michigan statute and the DC statute. And as I think Your Honor recognizes, in WM, the court did indicate that there are some differences between the statutes and went beyond what either the Supreme Court had reached in the Alaska case or in the case that followed in the same year.
Thank you.
I believe that given the nature of the court's questions, I don't think there's really anything else that I need to address on constitutionality. The only thing that is left to do is just to point out something that I don't know that really came out in the government's brief on the set-aside issue. This is my fault for not emphasizing it enough. So there's another way, in addition to the burden of proof issue, that it's apparent that Mr. Hickerson wasn't actually granted an unconditional discharge, which is what was required to get a set-aside after only 3 months in a halfway house. If you look at 18 USC section 5017, which discusses conditional release, unconditional discharge, and then also, the period after which a conditional release must happen. Section B indicates that an unconditional discharge will only happen at the expiration of 1 year from the date of conditional release. So it would have been illegal for Mr. Hickerson to have been released from a halfway house and been unconditionally discharged at that time. He only could have been unconditionally discharged a year after he was released from custody. So in addition to the burden of proof issue, we also know that his assertion of fact that he was unconditionally discharged after only 3 months just isn't possible under the statute. And that's just something that I wanted to emphasize that wasn't necessarily apparent from my brief.
Well, is it clear that he's saying that he was unconditionally discharged immediately after being released? I mean,
yes.
Yes.
Yes, that from his pleadings and from his brief.
I mean, I understand what he's saying. I was let go after a year and then 3 months in a halfway house and never had to answer, come to another status hearing or report to a probation officer. So clearly I was unconditionally discharged. Now, maybe it was a year later because you say that's what the statute would have required. It doesn't strike me as changing the fundamentals of his argument, though.
I don't see that as a separate basis for, because I actually think the burden of proof question is an interesting question, right? If you have this administrative review to decide issues of fact, and we have said that those, at least as far as, proving up whether a conviction is a qualifying conviction because it used, because there was a use of force, the burden of proof is definitely on the government to show it's a qualifying conviction in that respect. Doesn't seem like a big leap to me to say, and the burden of proof should be on the government to show that the conviction wasn't set aside, right? Under this well-established, statutorily defined process. I'm just not sure that it matters given how SORA is written, whether SORA is written as subject to, constitutional challenge, because it really doesn't seem to have a rational basis, is not an issue that this panel can address, but
yeah,
that's how I see the issues.
I certainly agree with the latter point, that it ultimately isn't really of moment, given the way that SORA is written. And then I suppose the only thing to point out is just that in Norris versus United States, 2007 opinion of this court, which follows WM, that the court did indicate that the burden would be on the moving party, so on a petitioner, to show that his conviction had been set aside. So the court indicated in WM that it would be inclined for registration disputes, and perhaps I should take a step back. Under the statute that addresses the claim for judicial review, which is 22-4004 A1A. A1A addresses factual disputes such as whether force was used, whether someone was under the age of, I think it's 12. And then there's a section A1B, which addresses when a person asserts that the records are erroneous. And in WM, the court indicated in dicta that being inclined to place the burden with petitioners for section B disputes. And then Norris actually addresses that question. And in its remand instructions says that the burden would be with petitioners for to prove whether a set aside's actually occurred.
Right, but his claim here, Mr. Hickerson's claim is not that the records are incorrect. He's saying your records are incomplete and I don't have them, you had them. So it should be on you, the burden should be on you to show that this statutory process that I remember occurring didn't occur. And that doesn't seem clearly wrong to me. And I'm not sure how Norris really helps. That seems to be a different issue.
Yeah. I guess I read Norris to have directly addressed this. It was an FYCA offender who was moving to compel issuance of a set-aside certificate. And this court said that on remand that it would be his burden to prove that his conviction was actually set aside.
Right, but I guess my point is Mr. Hickerson's not moving for the issuance of a certificate. He's saying this did happen, and you all you lost your records. That's the government's problem. If the government wants to then rely on records, it seems like the government wants to rely on the omission of records, and that seems problematic. But ultimately, again, I'm not sure that matters.
I take your Honor's point. If there are no further questions, we would ask that the judgment of the Superior Court be affirmed.
Thank you, Mr. Carroll, and Ms. Cresta Savage, we'll hear from you for just a couple of minutes. You're muted.
There. Thank you, Your Honors. I apologize. Given the questions of the court and the argument of appellee's counsel, I think it becomes even more clear now regarding the burden shifting that the two statutes, the FYCA and SORA, collide because, as stated by Mr. Carroll, under 22-4004A, which I think applies to Mr. Hickerson, it's the government's burden to prove that, in fact, if they want him to register, that in fact his case was set aside. There were exhaustive efforts to try to find the records, and nothing could be found due to the closing of the Board of Parole, et cetera, that I mentioned earlier. In addition to Judge Washington's point and the Michigan statute, what I think is important is that DC's code is in the criminal section. There is some question as to whether it's a civil penalty or a criminal penalty, and I would argue that while, as Mr. Carroll had mentioned, maybe the penalties have lessened, there are still nonetheless penalties that ensue if someone violates the registration requirements, and that everything up and including incarceration. So again, I would argue that it is in fact punishment. To distinguish Smith versus Doe from a recent Sixth Circuit, as I mentioned, the Tennessee Circuit, and Doe versus Snyder, I would argue in this case, public safety and rehabilitation collide, as FYCA says, don't put FYCA set aside arrests on public record, and SORA does just the opposite. So therefore, to find that the SORA as applied to Mr. Hickerson's unique set of facts and the fact that he has been sex offense arrest free for over 43 years needs to be taken into account and is a violation of his ex post facto constitutional rights. It makes it more burdensome, the punishment imposed for offenses committed before its enactment. I would also disagree with Appelli's argument that the purpose of SORA is to make sure people don't get arrested. Well, no, it's not that. It's to make sure they don't recidivate, for lack of a better word, that to ensure that no one commits further sex offenses. And in this case, the burden of proof, or Mr. Hickerson has proven that. Finally, Your Honors, we request that the court find that the court or parole record prepared and maintained by government agencies constitute the proof that in fact this was set aside. Under the rule of lenity, he should be given the benefit of the doubt. And if the purpose of official proof is missing, then under the rule of lenity, the situation should be interpreted on the side of Mr. Hickerson and assumed to be set aside. That proves that he served less than 6 years under the FYCA sentence. I believe my time is up. And for that reason, Your Honors, we would ask that you overturn the judgment of the lower court. Thank you very much.
Thank you, Ms. Cresta Savage, Mr. Carroll. We appreciate your time today. You may log off and this case will be submitted.
Thank you, Your Honors.
We're in the next case.
The next case on our calendar is 19 CV 912, Jordan Marcus Thurman versus the District of Columbia. Mr. Napa, when you are ready, if you could introduce yourself for the record and let us know how much time you'd like to reserve for rebuttal.
Good morning, Judge Easterly. I'm the attorney for the appellant. I would like to reserve 3 minutes for my rebuttal, please.
Can we adjust the clock? We need the clock to be at 12 minutes, please. Thank you.
All right.
Great. Go ahead, sir.
Good morning, Judge of the Court. My name is Neil Depo, attorney for the appellant. Good morning, counsel. Now, in this case, it's a constitutional civil rights case. I believe a serious case. We have serious injuries. There are allegations of excessive force in this case. I hope you all have looked at the facts of the case as counsel and I set them forth, because I didn't want to spend a lot of time on the case. But what we have is my client basically was late for school. The school locked him out. He, along with 2 other late nicks, decided to go to the great-grandmother's house of my client. And he said, let's go and chill. He was not allowed to be there. He did live there in the past. And his uncle was residing there at the time.
Counsel, I think we're familiar with the facts as you have outlined them in your brief and of course as has been outlined by the appellees. The threshold inquiry is, I think, I don't think you necessarily disagree with, is whether the plaintiff's allegations, if true, show that the officer's conduct violated a constitutional or a statutory right. If it does, the court has to decide whether the right, the right that was violated was clearly established at the time the alleged violation occurred. And your brief relies in large part on Fourth Circuit cases to establish the right. Of course, we're not bound by the Fourth Circuit, and there are other circuits that have contrary positions, and we have not yet spoken on the issue directly. So under those circumstances, how can this court find that the right has been, was clearly established at the time the alleged violation occurred? A constitutional right, not whether it violates MPD policy, not whether it's, it meets negligence standards, but whether there is a constitutional right that was clearly established under those circumstances.
Yes, thank you, Judge Washington. I would argue that every citizen has a right under Graham versus Connor, the 1989 Supreme Court case issued the decision by Judge Rehnquist. All claims that law enforcement officials have used excessive force, deadly or not, in the course of an arrest are properly analyzed under the Fourth Amendment's objective reasonableness standard. And that's what I would urge the court to consider in this case.
I think the question, though, is what is your strongest authority that clearly establishes this was unreasonable?
I believe that it's a combination of facts and law. This was a very unreasonable search in that, in our view, the officers did not gather the necessary facts to assess and properly deal with this situation.
I'm very interested in that aspect of your claim, more so as it relates to the negligence part of your claim rather than the constitutional claim.
Yes.
What do we know about? Did the information stop with the 911 call that this kid claims to be the grandson of somebody who lives there? Is that where that information died? Did it get passed on to anybody? Judge
Deal, if you received the MP3, it's a little flash drive, and I attached it to the appendix. Should look like this. We have the police's own words. And I think the court had contacted me about a month ago and said, yes, it was attached. Now, what we know is the 911 call, an elderly neighbor across the street was told by the gardener that three boys had broken into this house at Chillum Place Northeast. That call lasted 1 minute and 56 seconds.
She said little boys, right?
The elderly neighbor was a man, Mr. Green. He's deceased now.
Huh.
3 little boys, and he repeated it 3 times. Now that may have been his way of speaking. He seemed like a very elderly man, and that's a nice colloquial way of doing it. But now the 4D tech is what I really want you to consider. At 1 minute and 48 seconds, Officer Williams, I think it was, said one of the boys said he was the grandson who lost his key. That was broadcast. At 3 minutes,
that was broadcast, and what's the state of the record on?
That was a 4th district tactical. I think it was broadcast to the K9 officers, but at any rate, the officers at the scene had this information. At 3 minutes, you'll hear that K9 is en route. At 6 minutes and 20 seconds, 3 apprehensions juveniles. Now, how do you go from 3 minutes to another 3 minutes and 20 seconds and the boys are already apprehended? How would it be possible to gather all the information? That's our position. At 9 minutes, the juveniles are to Children's Hospital. At 12 minutes and 50 seconds of this 4D TAC audio, they're at Children's Hospital. And at 16:55, because I went over this second by second, there was broadcast a juvenile with severe injuries. He names Thurman. He says he's going to Howard University Hospital. Now, that is done with such acceleration and rapidity. I just feel that, and I argue through my brief, with an unleashed canine, how can you gather the information in that little a time? Now, I know the officers like to show up and deal with a dangerous situation. I know that. However, if the kid is a grandson who lived, who was related to the homeowner, shouldn't that have been gathered? Shouldn't that fact have been gathered? Now, we've heard a lot about the word guns. I call it the G word. Guns changed everything. Both officers said that. And I appreciate that. I've got another G word, grandson. Grandson. That should change everything.
Mr. Napo?
How many
so you're-
Yes, sir.
Mr. Napo, I'm sorry. Yeah. So what you're suggesting is that there's a duty, which of course is outlined in the municipal policy on the release of canines and juveniles in cases involving juveniles, that they gather the facts. And that you're saying the timeline clearly shows that there was a violation of that duty because there was no attempt to gather facts. And is that the argument that regardless of what they ultimately determined, they did not do what they violated the standard of care by not investigating before releasing the dogs with or without a warning? Is that your argument?
That's part of it, Your Honor. There are built-in protections for juveniles within the general order, and I hope I set out some of those.
You did. We have the general order, but your argument here today seems to be based on a timeline that you seem to be arguing was unreasonable. It was too quick between the time they get the call, especially when they get notice that there was at least a representation by one of the individuals that he was the grandson of the owner. There is evidence, or there was subsequent testimony, I guess, that the grandfather confirmed that the grandson was, that this individual was actually his grandson?
No, the uncle, I'm sorry, Your Honor.
The uncle, right, I'm
yes,
sorry.
who resided there.
Right,
By the way, you see, about the guns, I didn't mean to cut you off, Judge Washington.
that's okay.
But about the guns, you see, we heard that guns change everything. However, one of the officers was clearly told, and it's in the case summary report, that the gun or guns were locked in a safe. And on deposition, the uncle said, not only were they locked in a safe, but they were downstairs behind a secured gate or door. So that in my mind, if you have this wealth of evidence about guns, and you know you're dealing with juveniles. Now another contention I have is Officer Reynolds, the main dog handler, said he didn't know the age. Well, how could you know the exact age? But he said he didn't know the sex of the suspects. Now, if you have 3 little girls, don't tell me you're going to release an unleashed dog without a warning. Maybe he misspoke. He had to know they were boys, but I'm just saying we have this kind of a low level of information. And remember, in order to protect juveniles, which I'm sure the district means to do, there are factors to be weighed after the intelligence is gathered. The severity of the crime, the age of the suspect is the second factor. whether he's armed or unarmed. Now, these boys showed no guns poking through the windows. They were upstairs and hiding under blankets. And whether they display violent behavior. Now, the severity of the crime, let's address it for a minute. If you have, and if you found out, I agree, they may not have known it, but if you found out there was a boy who was, related to the homeowner, I would say again, how severe is it? It's not a burglary. He was ultimately prosecuted, add insult to injury in my view, but the court found him guilty of unlawful entry. Well, that's not burglary. And if the officers who had set up a perimeter now, Officer Jones saying that there was no rush, there was no exigent circumstances, that they had all day if they wanted to, but why not give a command to these terrified teenagers? In my view, that's I would have been if I were 13, 14, or 15, which the boys were. Why not give a warning at least before you assume that we've got really bad suspects that are armed and burglarizing? It just, to my mind, I'm just trying to make.
I just want to. You gave one answer earlier. I just want to nail it down before I see your time's up. But as to the broadcast, that one of the boys says it's his grandparents' house. Are you saying that the evidence in the record is sufficient to permit conclusion that these officers who you sued heard that broadcast? Were they asked if they heard it? I assume the answer, they said that.
I asked them if they heard it, both on deposition. They said no. However,
because the radios were off, because they just weren't paying attention. Anything?
I think it was before they were dispatched. Counsel could maybe clear me up on that. But Judge Deal, when you get to the scene, your duty is to gather the facts.
I understand that part. I understand your part that that they should have inquired.
They should have
I'm just wondering if you have. I'm just wondering what the state of the record is, so that we can evaluate. I understand that part.
Yeah, they did not speak to the homeowner. I've got a couple of quotes from the depositions where until after the event. Now, if you're worried about the guns, speak to the homeowner. Wait till he gets there. There was no rush. They had a perimeter set up, and the boys weren't trying to escape or flee or show guns through the window. I mean, the whole tenet of this setup seemed to go against the general case law, because in the case law, Your Honors, if I've got a minute, I can't tell how much time I've got, but I've got 6 basic cases that deal with this type of case. Number one, though, is Graham versus Connor, where you got the reasonableness standard of the Fourth Amendment. Look at the severity of the crime. Does the suspect pose an immediate threat? Now, I dwell on the word immediate. There's no immediate threat. They could have stayed there all day, but I may be interpreting it wrong. Is the suspect resisting arrest or fleeing? That's Graham versus Connor. Now, we have 5 other cases. 2 are leashed dogs, okay? This is very important. Both cases, the officers were granted qualified immunity. Maney versus Garrison is 4th Circuit, as when that Judge Washington, and Melgar versus Green, another 4th Circuit case. There was qualified immunity found in those cases, but mind you, those are leashed cases. The officers have the dog under control, and in both cases, the person was bit. But the court felt, that the officers were doing their duty, and it was reasonable.
Mr. Napo, I'm sorry. I think we're familiar with those cases. Many of them are in your briefs. The question I have, though, and just as a final question, under the circumstances here, it's not clear to me about the severity of the injuries. Is that a factor that goes into our evaluation of whether there's excessive force? There's a lot being made of the fact that he was bit twice, quickly, within 10 seconds, got treatment. It was not like the mauling cases that many of the cases that you have provided to us. Is that something that we need to, that we should be taking into consideration since this is an excessive force case?
I'm very glad you brought that up, Your Honor. The boy's picture, right during the picture of his photos is at the appendix, page 107. You're going to see a lot of blood. The boy has permanent scarring. And again, our position is that there was no need for this without a warning at least issued.
I understand. I understand, again, going back to the warning and requirement. That's what I wanted to know. I'll look back
It's a
at that.
severe permanent injury, and the boy's been to, although I didn't put it in here, a cosmopolitan, what do you call them?
Cosmetological.
Plastic surgeon, I'm sorry. I didn't put that in because I know the arguments are mostly going to be legal, but I'm glad you brought that up, Judge Washington, because the case the trial court relied on, with all due respect, is Crenshaw versus Lister. It's an 11th Circuit case. As I emphasize the 4th Circuit because Virginia, Maryland, but this is 11th Circuit, Florida, Georgia, and Alabama. And in that case, I couldn't see the court's point of view because we have an armed robber who held up one or two stores, they said. He was fleeing in his car from the cops. He crashed into one of the sheriff's cars. He then got out and dashed into a canal in a dense wood. They were chasing him on their bellies through thick brush. And the court seemed to rely on that to say that the officers should get qualified immunity. Now, in that case, the court said you have to balance the need for force versus the amount of force, the extent of the injury, and was it good faith or malicious? Now, the fourth one doesn't answer to that. These were very fine officers. But the first three, I mean, that's the court really relied on that case. And I couldn't see that when you have such a man, a violent adult fleeing. Remember, we have boys here. We have juveniles.
Counsel, I think we understand your argument and why you would distinguish the 11th Circuit case, and I think we'll hear from the government now.
Thank you, Your Honor.
Thank you.
Good morning. May it please the court. I'm Lucy Pittman on behalf of the District of Columbia, as well as officers Craig Reynolds and Daniel Jones. The court should affirm the Superior Court's judgment in favor of the district and the officers in this case, because Mr. Thurman has not established that there is a constitutional violation. And I'm going to start with the Fourth Amendment on the merits and then as well as the qualified immunity analysis before I get to the negligence count. So under the Fourth Amendment, the officer's use of a canine without a warning to locate burglary suspects that are concealed in a home where they have a reasonable belief that there are weapons, loaded weapons available in that home was objectively reasonable. And there we can take a look at two 11th Circuit cases. The Superior Court relied on the Crenshaw case, but the Grimm's case is also relevant, where you have a burglary suspect, you have concern that there is a weapon, that the individual is hidden or concealed from officers so they can't immediately assess whether or not weapons are in the hand, and a canine was used without a warning. And in those cases, the 11th Circuit affirmatively said under the merits of the Fourth Amendment that it was objectively reasonable to use a canine in that instance. And that makes sense because when you look at the interest, there is a weighty government interest here where you have burglary suspects, albeit juveniles, a fact everyone knew, and initially was a reason not to use the canine unit.
But not just juveniles. The report says he's the grandson, lost his key. So talk to me about that for a second. What about this aspect of the claim? And I'm much more interested with regard to negligence than the Fourth Amendment, but we can talk about it in terms of both. What about that aspect of the claim? How is it reasonable? How does somebody not figure that out? That seems like a critical piece of information that officers on the scene might have inquired about. What do we know about these people who broke in? Oh, they're little kids, and one says his grandma lives there, and he's got a key, but he lost it. That seems like a whole different ballgame. So what's reasonable about not figuring out sort of the basic facts of what you're dealing with?
Well, I would respectfully disagree that the officers did not have the basic facts. And I think what's really important here is Officer Jones, one of the K-9 unit officers, spoke to Mr. Winkler, the lawful occupant of the home. And Mr. Winkler explained explicitly no one was allowed in the home. So the fact that he was the grandson of the owner is sort of no moment, because as it turns out, he wasn't allowed in the home. Mr. Winkler, upon identifying him,
It's of no moment whether or not a grandson is going into his grandma's house that he had a key to, or whether or not it's a stranger who's breaking in. Like, you don't think that changes whether or not it's a burglary or an unlawful entry?
I think being a relative can cut both ways. And so I don't know that a reasonable officer would know affirmatively what you're suggesting, which is that this means that this is a safe individual. There are lots of calls of domestic.
I mean, it's a very interesting question, but nobody made the judgment because nobody seems to have known on the scene when they deployed the canines that this person inside claimed to be the grandson. And so my question is, isn't it unreasonable not to figure that out? You know, isn't it unreasonable not to have, it sounds like it was broadcast. Didn't somebody need to relay that to the officers on the scene? Didn't these officers have a duty to inquire?
Certainly not under the Fourth Amendment would it be unreasonable when you take into account that they spoke to the lawful occupant of the home, who explicitly said no one was allowed in the home. No one and as it turns out, Mr. Thurman, despite being the grandson of the owner, did not have a key, was not allowed in the home, and was prosecuted.
Well, that's a disputed fact. He says that he had a key, that he couldn't find it at that time, but he had a key. That's part of the facts that they allege.
Correct, but Mr. Winkler was affirmatively saying he's not allowed in my home, and he was prosecuted.
Well, nobody said he claims he's a grandkid. Does that ring a bell? And maybe Mr. Winkler would have said, oh yeah, that does ring a bell. My nephew goes to school just down the road, and he used to come stay here a lot with his grandma. Right? Nobody asked him about it.
I understand that, and under the Fourth Amendment, that doesn't take this out of the realm of reasonable. When you have officers on the scene who do talk to the owner and do know affirmatively the individuals in the home, the suspects are not.
But don't know that the broadcast was for somebody who says he has a key and was a grandson. They could have asked what was the broadcast, right?
I'm sorry, I misheard. I didn't.
But they don't know what the initial broadcast was. And the initial broadcast, as I understand it, was that the person climbing through, little boys as they were described, claimed to be the grandson of an occupant. They don't know that. So when they ask Mr. Winkler about it, they don't have the knowledge to kind of trigger his memory of that, right?
I understand that, but Mr. Winkler also had reports of the burglary from the same individuals who called the 911 report. And so it's not entirely clear if he was also told that it was a grandson. Or as it turns out, it would have been his nephew. I think what's key here is what you have on the scene is officers taking they're doing an investigation, they're talking as the general order requires with the owner of the home, and they're finding out that there are people in the home who are not allowed to be there. And most importantly, 3 loaded weapons that Mr. Winkler described as being concerned that these suspects could obtain those weapons and use them. So under the Fourth Amendment, and I understand that you view this more as more of a negligence issue. So if you want, I can move into the second prong of qualified immunity and then move on to negligence, since I can just sort of wrap that up if that's what the court would prefer, which is that even if, and I fully recognize there is no DC case that's specific to this matter, and that's really relevant for the qualified immunity standard, which is that you have to have a controlling case with materially similar conduct or a robust consensus of cases. And as the court has already noted, the Fourth Circuit, there's a couple of cases there. That's not a robust consensus of persuasive authority throughout the nation. And the Melgar case and really muddies that up. And so I think this is a case in which qualified immunity is certainly warranted, and there isn't much actually in to say otherwise. And so if the court would prefer that I move to negligence and just not touch Fourth Amendment any longer, I'm happy to do so. And so I'll actually start on the negligence count where the court determined it, the Superior Court, which is that an expert was required to establish the standard of care. Determining whether or not an expert is required is an abuse of discretion standard, and there is absolutely nothing in Mr. Thurman's brief indicating that the Superior Court abused its discretion in holding that an expert was required. So let's take a look at.
But Mr. Napo argues that he he provided that information sufficient to defeat the summary judgment motion, because his expert talks in terms of standard of care and relies on to a large degree on the district's policies, but does talk in terms of standard of care and the question of whether to release dogs under circumstances when there is so much policy seems to at least may not even be a question that requires expert testimony. But if you needed it, your expert and their expert seem to agree that there was a requirement for further investigation before the dogs were released without a warning.
So I would disagree with the premise that his expert does adequately establish a national standard of care. And there is absolutely nothing in his testimony to link his opinion to anything other than his years of experience and the general order. This court has, in many cases, said that that's inadequate, and I can point the court to the Blair.
Counsel, the general order is, according to your proffered expert, adequately sets forth the national standard of reasonableness. And this, Appendix 268. MPD's own policy follows this national standard by requiring its officers to use extra care. I don't understand why we don't have the necessary standard provided by your own expert.
So I would actually disagree that our expert says that the general order is the national standard. In many cases, he says that our general order exceeds the national standard.
Yes, sometimes, but he does say what the national standard is. He says, use of standard, the national standard is reasonableness. I find this to be reasonable, and then quite curiously omits several facts like the guns were in a safe. That doesn't seem to be any part of his analysis. That these were claimed to be grandkids. That doesn't seem to be anywhere in his analysis, though I take it as a disputed fact whether or not these officers should have known that information. And he doesn't talk about what they should have done to figure it out. And that, to me, doesn't really call for an expert. Should officers arriving on the scene take a minute to figure out what they're dealing with? Probably. I mean, he doesn't say anything to the contrary. Sure, when I read his report, it seems like he would say if he had known all these relevant facts, he might not have reached the conclusion that he reached. And it just strikes me as something that a jury might be able to weigh.
So I disagree with that for a couple of reasons. One, let's start with the burden is on Mr. Thurman to produce a national standard of care expert, which he has not done. So we don't even have to get to our expert before we do that. And I will refer this court to the Blair decision.
The evidence is in, I'm sorry, counsel, the evidence is in the case, right? I mean, we're not talking about burdens. We're at summary judgment, and there is evidence in the case, and we have your expert saying in his report, quote, the MPD's own policy follows this national standard by requiring its officers to use extra care when deployment is considered in the case of a juvenile. And it continues, right? So the extra care when a juvenile is involved for use of a canine unit is the national standard and is in the MPD's general order and is conceded by the district. Why are we talking about this?
And our expert found that our officers met the national standard of care.
Right, but then that gets to Judge Deal's point, which is he found that they complied because he apparently didn't seem to have facts or wasn't considering facts that would have been very material to this assessment about whether extra care was taken. So you have a standard that the district has conceded is the national standard, and then you have this incomplete assessment of facts to determine that the national standard was complied with. That just seems wrong. That and if our standard of review is abuse of discretion, it seems clearly an abuse of discretion to say that that's correct.
I would respectfully.
You can't just ignore the bad facts and then look at some incomplete set of facts and say this is okay, it complies with the national standard. That's just not how we do things.
I understand that, Judge Easterly, and I do understand the point you're trying to make, but if I can go back to something that Judge Deal said, which is that the expectation that you do have officers who take a minute to investigate. Certainly, these officers did know relevant information. And I think what's really important here is the conversation that they have with Mr. Winkler prior to entering the home, where Mr. Winkler explained that no one was allowed to be in the home, that they did in fact take into consideration the relevant facts of that they were juveniles, that there were guns in the home, and that they were wanted for, or that they were suspects for burglary, that they had broken into the house. Those are all relevant facts. The fact that they were playing hooky is not something that, I mean, they could have asked everyone on the block and they never would have learned that. That's something that you only learned after Mr. Thurman was arrested, that he had been locked out of school.
Yeah, I don't care that they're playing hooky. I care that the guns are in a safe, which is a fact that your expert doesn't seem to know, not in his report anywhere. And I care that one says that he's the grandson and had a key, that apparently nobody took information that nobody took the time to gather. And Mr. Napo says the gap in time between the officer's arrival and apprehension was about 3 minutes. Is that right?
I'll be honest, I don't know that. That's new. He did not brief this. This is a new argument for today's argument. So I have not had an opportunity to look at the merits of that. But I will say the safe is an interesting point, because I think what you have is our expert is explaining the facts based upon what Jones and Reynolds knew. Jones and Reynolds Jones specifically spoke to Mr. Winkler. Mr. Winkler never told him the guns were in the safe. He explained that there were multiple weapons in the home. He described the various locations.
That's what Mr. Winkler says?
Yeah, Mr. Winkler in his deposition testimony says he doesn't recall if he told Jones about the safes or not. But Jones was able to identify in pretty great detail the location of in the studio, but there was no mention of a safe. So these officers didn't know that there was a safe. Although the safe, given Mr. Winkler's concern that the suspects could obtain the weapons, I don't know that the safe by itself would be a determinative factor. Mr. Winkler is the person who knows how secure these guns are or are not. And he has an affirmative concern, so much so that before he even got back to his house, he called Sergeant Green, a friend, to let him know that there were 3 loaded weapons in that home and that he was concerned that burglary suspects could obtain those weapons and use them against officers. So it is not.
Did you tell him that the kids said that they were grandkids and had a key?
I don't know that.
Did that get relayed down the pipeline anywhere along the way?
Judge Dale, the record doesn't indicate whether the neighbor who called Mr. Winkler said that it's your nephew or your a grandson.
Did anybody talk to the neighbor on the scene?
Yes. We don't have details on the record other than Officer Williams spoke to the neighbor, but there's nothing else in the record with regard to that. So to say that an investigation was not done here, I think would just be completely inaccurate. And to indicate that the officers did not have adequate information when they spoke to Mr. Winkler and they knew the relevant facts of the burglary suspects, the loaded weapons that they could have access to, and that they were concealed in a home. Not only was this reasonable under the Fourth Amendment, or certainly not a clearly established violation, and under the negligence standard, there is simply nothing in the record to indicate that they violated the national standard of care.
Ms. Pittman, I just want some clarification because I had a different impression of the facts. The neighbor on site that had the conversation with the grandson, nephew, and witnessed the boys at the house. I thought the testimony was that when the police arrived, he mentioned that they were, to the first police on the scene, that the individuals going into the house, one had identified himself as the grandson of the owner. Is that not correct?
It's my understanding that that was the discussion with Officer Williams. The record isn't entirely clear, but that is my understanding based upon the record, that yes, they did speak to him, and yes, he did relay that information to one of the officers. And that obviously wasn't a key.
But it was not relayed to the canine officers.
No, neither Reynolds or Jones knew about that. They did know about the juvenile status. They did speak to Mr. Winkler to know that no one was allowed in the home. And what's, I think, important here is Winkler confirmed he wasn't in the home thereafter and that he didn't have a key. So I know I didn't touch on the municipal liability. I'm going to rest on the briefs unless the court has any questions on that. But I do see that I'm out of time, and I want to be mindful of the court's time this morning.
Thank you, Ms. Pittman. Thank you for your argument. And we'll hear from Mr. Napo just a few minutes in rebuttal, please.
You're muted.
Mr. Napo, you're muted.
Oh, I'm sorry. I'm awfully sorry. I didn't see that. I did want to touch on the issue of the municipal liability if the judges would permit. And according to Monell, if there's a city policy which infringes on constitutional rights, that city should be liable for that.
Mr. Napo, we're not talking about a policy that infringes on, I don't think that's the standard. Isn't it a policy that in fact, well, infringes on, I'll go with your terminology, but isn't this an issue of whether the policy itself forces or creates the constitutional violation?
Yes, that's
And this
exactly-
policy doesn't require them to release the dogs without a warning. There's nothing in this policy that creates or establishes some or a policy that for which they could be held liable, because it doesn't force them to take certain action, correct?
No, Judge Washington, I agree with you there. This policy, which is at the appendix, page 171, it's at the bottom.
Right.
It's under warning announcements. And I find this particularly egregious in this case. The warning announcement may be omitted from a search in those exigent circumstances where specific articulated facts demonstrate the need for complete surprise or where the announcement may place the handler in imminent danger. Now, you see, I think without gathering the intelligence, this policy is fine, but I'm sorry. This policy is fine where you have all the facts, but without gathering the facts, this is like an out to let officers kind of run rampant and speedily wrap up something which should have been handled a little more carefully. That's why I feel that the district should be held in the case on the Monell standard, because I think this policy for officers who are not doing their duty, let's say they shot a machine gun into the window or something, officers who are not doing their duty have an escape clause here, which I think infringes on my client's rights.
Thank you.
Do I still have time? I don't see any clock. So that was
A few more seconds, Mr. Napo, if you could conclude.
well. That was my point about the DC policy. It may be a weak point, but to my mind, it lets an officer out where either there's been some kind of a break in the information chain or some terrible development happens where it's a big mistake, and this just lets them out. And I feel in this case, and maybe in others, this could infringe upon constitutional rights if the officers haven't done their job properly. That was my point about that. And to the expert, I wanted to say that I got a retired police captain of 29 years in Baltimore City. His affidavit is replete with references to negligent training and supervision, how the officers were negligent and overlooked a lot of facts, and in general it seemed to be a little messy, and again resulting in these terrible injuries for my client. So we just want to all be reasonable, and I think in future learn from a case like this, where I submit a little more care could have been taken, and this whole incident could have been avoided if you ordered the boys to come out. They're scared boys, they're juveniles. They can't vote, they can't drink, they can't, they're not making rational decisions like adults. And that's most of the case law we have. These are boys, so I wanted to bring, I'm sure the court's aware of that, but That's all I have, and I appreciate your time and attention very much.
Thank you, Mr. Napo. Thank you, Ms. Pittman. We appreciate both your arguments. The case will be submitted and you may log off.
Thank you, Ms. Pittman.
Bringing in the next case.
The third case on our calendar today is 19 BG 1207. Enray Ole Kanama, Ekewewe Kaufman, and counsel, or Ms. Ekewewe Kaufman, if you would introduce yourself for the record and let us know how much time you would like for rebuttal. And if I could trouble you maybe to adjust your camera just a little bit, we're getting the top half of your face. There we go. Thank you.
Is that good?
Yes, thank you very much.
Okay, thank you.
Whenever you're ready.
My name is Olekama Ekewewe Kaufman. The respondent or the appellant in this matter. Should I proceed or should I wait?
You may go ahead with your argument. Where the sound isn't great, I think it will help if you keep the microphone in front of you while you speak.
Excuse me for a minute, please. Is that better? Is that better?
Yes, it is. Go right ahead.
Yes, I'm the appellant in this case, and I requested this. I requested this appeal because I believe the board erred in their recommendation in taking the decision that they take and the recommendation that they made in my case. This was a disciplinary hearing case that was brought almost 11 years after the fact. And the decision was based on facts that were not substantiated. The decision was not based on fact that was presented at the hearing. And the bar counsel did not meet the clear and convincing evidence that was required to reach the recommendation and the decision that the board presented. So I took an exception to that. And starting with the issue of clear and convincing evidence as stated in Anderson 778A22D33 DC 2001, they said to have a clear and convincing evidence must be more than preponderance of evidence. And also in Imre Carter 887A2D1 24 2005, the court stated that the trier of fact must have a firm belief in the facts sought to be established. The facts that were presented in my case were quite different from the conclusion of law and facts that the board presented. For instance, one of the issues that the board indicated that in my case is that I failed to represent a client, Ms. Florence Myers, and that is incorrect because there was no representation involved in that case. Ms. Meyer came in as a consult.
Mr. Ekewewe, could I
Yes.
just maybe direct your attention to what I'm most interested in?
Yes.
Because the allegations as to Ms. Myers really aren't at the heart of led to the recommendation that you be disbarred, but instead at the heart of that are the allegations of misappropriation. And in particular, the May 2015 misappropriation really as to 3 different clients. And as I understand it, the argument goes, you had this trust account, had a lot of money that was due to those 3 clients, and you moved a lot of it to your operating account so that your balance fell in the negative. Not just the negative, but well below what you needed to cover those client expenses and the money amounts due to them. And that is misappropriation. Now, I don't hear you saying, I suppose I want to get, what's your response to that being misappropriation?
That's actually incorrect facts. The facts of the matter is the 3 clients, and I must point out, those 3 clients does not complain to the bar that their funds were misappropriated. The bank did not complain to the bar that or the providers did not complain to the bar that the funds were not paid to them. This is bar counsel. Of course, they have a right to go and check everyone's account if they choose to, but this is bar counsel targeting me for prosecution on those 3 clients. If you look at the appendix or the documents that were submitted, it shows that each of those clients' accounts, the providers, the clients, everything was paid. It was
I understand that, but it's actually a little bit concerning to me that you think that obviates a finding of misappropriation. Because even if you misappropriate and then make it right later on, you've still misappropriated. But from your brief, I don't get the sense that you acknowledge that. And it's concerning when this is not your first, and I understand we set aside the finding of misappropriation last time, but it's concerning when a second time, your defense to misappropriation seems to be, sure, but who cares? That's what I'm hearing, which is they got their money eventually, so who cares about a little?
No, that's not the case. Let me be clear. They were not misappropriation as far as I see. And my defending this position does not mean that I'm taking a cavalier attitude about it. That's not the case. I don't want you to misunderstand me. And I don't want anybody else to misunderstand me because of that. My position is this. First of all, there were some instances where the check were presented and it was not credited before the providers or the client sought their check, because usually when the check come in a personal injury, they run to the bank right away to pick up their money. And sometimes the bank might hold the account, might hold the funds and not clear right away. And sometimes it clears right away. So my position, and if there was a discrepancy because the check came in before the other one clears, then in response to the bar, I apologize for that, just to show that, yes, I'm aware that this happened. It was not intended for me to misappropriate money or take money that was not due me, which I did not do. And I cleared to the bar that this was not the intention. There was no money taken for my purposes that was not due to me.
Is it correct way?
Yes.
The bar count, the board
Mhm.
Indicates that there was evidence presented that your trust accounts and your operating accounts were being used interchangeably, that there was money going back and forth between those accounts. And on several occasions, your trust accounts were far below the money required to address the needs of your clients or to compensate your clients for their injuries. Is that a fact that you say there's no evidence to support? Because at the point where your trust funds are dipped below what is required, and there is money being transferred between your operating fund and your trust fund, especially your trust fund to your operating fund, and it's below, that minute is when the misappropriation under our case law occurs. Are you saying there was no evidence of that presented by bar counsel to the hearing committee or to the board?
What I'm saying is that there was not, maybe transfer, my interpretation of transfer is different from the board's interpretation of transfer. There were checks that were written as part of personal injury case that went from my account to client's account to provider's account and to me. And those were clearly stated in the disbursement sheet. And those were clearly attached to the bank account. There were a brief moment, I think there was one clear indication where there's a discrepancy where the amount fell by, I think, 19 cents, $19. During the testimony of bar counsel's supposed experts, they stated, well, there was interest taken out and then it fell below. It's supposed to be $2,000 at this time, but it was 19 something. There was no clear indication, or there was nothing showing that I took 19 or $20 out of my operating account into my account. And during the hearing, I attempted to make it clear that there was no time during those three cases that I took money out of the operating account to my account that were not already dispersed according to the sheets, the disbursement sheet, and according to the agreement that was signed up between the clients and the office. And the issue I have with the presentation of the misappropriation is the way that the expert, I would say, maybe saying fudge the lines, the way the expert presented it, that was not clear. First of all, I took issue with this particular expert because he did not do any investigation to see if this, what he claimed or what bar counsel claimed actually happened. He said he reviewed the record. I objected to his testimony. The board refused my objection. And during that cross-examination, I also found out that he did not talk to the bank. He didn't talk to the providers. He didn't talk to my client. And that's part of the record. And he didn't talk to anybody in my office to see if what they're claiming is correct. I know they have a way of presenting the misappropriation so that it would be in their favor. But in this particular case, I don't believe, and I know that I did not misappropriate funds. Yes, there were a previous hearing where they presented a plethora of things that claimed that I took clients' money. And thank God that the court did not find that it was misappropriation. And then, even this particular misappropriation case should have been brought at the same time because all were running at the same time. But because they want to make sure that they have this tag on or consecutive punishment on me, if they could get it, they broke it down into one finish, then you start at the next one with an expert who doesn't do a thorough investigation, who doesn't review all the facts, who's not even licensed to be an accountant, to be presenting an accountant expert testimony. That's some of the issues that I have, that I felt like even the board they asked for recommendation on finding of facts. I presented my position. It seemed like the board didn't even look at that. They just took whole and parcel of what bar counsel presented without applying any of the statements that I made. For instance, they claimed there was no showing that the providers were paid, when there's clearly documents that shows checks that were paid to the provider and that paid to the clients. And when I say each of it was honored, it's not saying that, oh, there was money missing and then you transfer money afterwards. That's not the position that I'm taking to say, well, oh, it's okay to misappropriate. No, it's not okay to take somebody's money. And I've never done that, as far as I know, as far as I'm aware of. I know from the beginning, my issue was record keeping, and I've taken steps to correct that. But arguing that I've taken steps to correct that now, when I've already argued that, because this case should have been brought when the other case was brought, but they did not do that. Though it seemed like, though, there was prior conviction and now she's going to do another one. So that's why you should look at the prior sanction as a continuing bad act.
Thank you, Ms. Ekowe Kaufman. We will now hear from disciplinary counsel.
Good morning, may it please the court. Julia Porter on behalf of disciplinary counsel. The board did adopt the findings of the hearing committee, and they did so because there was substantial record evidence to support them, including.
Excuse me, Ms. Porter, sorry, Ms. Ekowe Kaufman, can you mute your mic, please?
Sorry.
Thank you.
Okay.
Sorry, continue, Ms. Porter.
Sure, including the finding that Ms. Ekekwe Kaufman engaged in 4 instances of reckless misappropriation. And I would like to correct her statements. In fact, some of the misappropriations were permanent. Some of the clients and medical providers to this day, or we have no evidence that they've ever been paid. And 3 of the misappropriations occurred more than a year after she'd been under investigation for her initial overdrafts of 2 trust accounts, one of which was shut down in the middle of 2014. There is ample evidence to support both the hearing committees and board's finding that Ms. Ekekwe Kaufman's misappropriations were reckless, including her indiscriminate commingling, moving funds from not only her trust account to her operating account, but another business account that she owed. And indeed, in the James Short case, that's one of the misappropriations. There was no paying the client or third parties before the check cleared. To the contrary, Ms. Ekekwe Kaufman received the settlement check in March. She provided the client a disbursement sheet, which she admitted set forth what she was entitled to, what the client was entitled to, and what third parties were entitled to. She took more than what she said she would in fees, and then she failed to pay the fire department. She failed to pay more than $1,300 to the Pain and Medical Rehab Center, the medical providers, and she paid some to Medicare, but not all of it, and she kept, the bank records confirm that she kept the rest of the money, and indeed, she misappropriated it when she took the $10,000 out of her trust account to put it in her operating account and then to pay the expense of her third party. And there's no evidence that she ever paid the client or the third party medical providers in the James Short case. And that's also true in the Dwayne Drew case, another misappropriation that occurred in May of 2015, a year after she'd been under investigation.
Ms. Porter, when you say under investigation, what does that mean? Does that mean she had been contacted, that she was aware that there was complaints against her and that she had been already asked to submit information about these prior allegations of misappropriation?
The investigation that I'm talking about is that the cases that are before you, I believe there are 5 cases. Mm-hmm. 4 of them arise, or 4 or 5 of them arise out of overdrafts. We opened an investigation in mid-2014 because of overdraft notices from both of her trust accounts at the time. As I indicated, one of them was shut down shortly after that. So she was under investigation for overdrawing her trust account as of mid-2014. Disciplinary counsel sent her letters, sent her subpoenas, also reminded her of her obligation to keep complete records of entrusted funds. 3 out of the 4 misappropriations that are before you today occurred a year later, in May and June of 2015, which is one of the, I guess, indicia of the recklessness that someone who's already under investigation for overdrawing their trust account and has been reminded on more than one occasion of the obligation to maintain, entrusted funds in trust and to keep complete records.
What is the longest?
I'm
I'm
sorry.
sorry, I'm sorry to interrupt, but can you just because I find it a little bit difficult to figure this all out on the record, what was the longest that her trust, and I think had fallen into the red? Had 2 days, 7 days?
Oh, no. She had, in 2014, Ms. Ikekwe Kaufman had 2 trust accounts. One of them was, I think it was the Citibank one, but anyway, one of them was overdrawn by more than $1,500 for 2 consecutive months, and the bank actually shut it down. The other trust account.
I mean, but was there evidence that that the funds of one of these clients that have been targeted were in that account?
No, the other, well, for example.
That's not going to do you any good, right?
Right. No, the James Short, for example, funds that she received, that the respondent received on Mr. Short, she received in March of 2015. It was an $8,500 settlement. She provided a disbursement sheet, which didn't reflect what actually happened. But that disbursement sheet showed deductions from the client's share for the DC Fire Department, $1,350 for his medical provider, and another $750 plus change for Medicare. Ms. Ikekwe Kaufman said she would take $2,250 for her fees. Well, the checks from her trust account reflect that she took $3,000 for her fees and additional $500 for expenses. She never paid the fire department, although she deducted that amount from the client's share of the settlement. She never paid the medical provider the $1,350 that it was owed. And although she paid Medicare $450, she pocketed the other $200. So that was a misappropriation that occurred over a couple-month period, and for which the medical provider and the medical provider, fire department, and clients have never received those funds. The same is true in the Dwayne Drew, another 2015 misappropriation, where she deducted almost $500 from the client's share of the settlement to pay the medical provider. She never paid it. There's no check to the medical provider. And after about a month, the trust account again was overdrawn. So some of the misappropriations, the LaToya King and the DePaul Eppright, were temporary in the sense that the medical provider and or client eventually got their share of the settlement, but there were misappropriations nonetheless. In the case of Short and Drew, there were permanent misappropriations that still have not been.
And what's in total? How much was misappropriated?
In the short case, based on my math, about $2,000 to the fire department, the medical provider, and what was due the client. And in the Dwayne Drew, it was $480.25 that was due to the medical provider, which is to date not been paid.
And the board found that wasn't intentional, right? Only reckless.
The board found, the hearing committee found reckless, and the board agreed. But under this court's case law, reckless misappropriation is disbarment under In re Adams and everything that's followed. There was a
Ms. Porter, that Ms. Ikekwe argues that all of this occurred in the same time frame. Now, I understand it's a year later, but she says she was going through training. Was there evidence of her office management and other circumstances to try to address these problems? Were those engaged in prior to this latest group of misappropriation allegations, or was that after the latest group of misappropriation allegations?
I don't know the answer to that question. I know that Ms. Akekwe Kaufman at some point, testified or said she had gone through some training, but I don't know if it was in connection with the first matter, in connection with these overdrafts, or
So
if
it was not, this is not evidence that was presented to the hearing committee or to the board.
well, she did testify, but as far as the timing, she didn't produce like evidence, like I met with
Okay.
the practice management assistance program and went through this training, and here's my certificate showing I completed it, or at least that I can recall. I do recall that she did testify to something to that effect. But this is not her first brush with the disciplinary system. And while the court did not find evidence of misappropriation in the first matter, they did find that there was a commingling and a mishandling of entrusted funds. And that is, we submitted an aggravating factor. And the two matters don't coincide in that the misconduct in the first matter, I think, occurred between 2005 and 2008. And the overdrafts and the misappropriations that are at issue here, we didn't get the first overdraft until 2014, and 3 out of the 4 occurred in 2015.
Thank you.
Unless the court has any further questions, we'd submit on the brief and we'd ask you to adopt the board's recommendation of disbarment.
Just a factual question. Disciplinary counsel said in its brief that the 3 years hasn't begun to run because she hasn't filed her affidavit yet, indicating that she's notified her clients of the suspension. Is that still true?
Yes. I, on behalf of disciplinary counsel, have corresponded with Ms. Akekwe Kaufman several times about what is needed to do to correct her affidavit, including she needed to notify the clients that were clients of hers before she was suspended about her suspension, provide their client files. And in fact, I've discussed with at least 2 of her clients the fact that they learned of her suspension after the fact, not from her. So that's one of the issues. Unless there's any further questions, thank you.
Thank you, Ms. Porter. Ms. Akekwe Kaufman will give you, I can't remember if we discussed giving you a few minutes for rebuttal, but we'll give you a few minutes. Just remember to unmute your mic.
Can you hear me? Can you hear me?
Yeah, yes, we can. Go right
Okay.
ahead.
Thank you. I just wanted to correct then a few things that bar counsel said. It's incorrect for them to say that in short case there was a misappropriation because fire department was not paid. There's a discussion on the record that after a time period, fire department sent the bill to collection, so they zeroed it out, and we then paid the collection company. There's a section in the hearing report where that issue was discussed and presented. So that's a misstatement or a misrecollection on the bar counsel part. And also to state that Medicaid was not paid properly is incorrect because there was a negotiated reduction for Medicaid, and that negotiated amount was what was paid, and the difference was given to the client. And it's clearly shows that in the checks that were presented to bar counsel as well as the board. All that is on the record that each and every provider was paid. There was no money that was taken for me from that account or from the reduction. Bar counsel now the issue of notifying the clients. Yes, I have notified the client. They bar counsel say that was not appropriate notification, and I've corrected that and submitted documents to the court correcting that. The last discussion with bar counsel last year, they still does not believe that's appropriate, and I've asked them, what else do I need to do to sure that all client has been notified, all prior clients have been notified, and all they said, well, read the rules. And I believe I was reading the rules, I'm following the direction, I'm posting what was required of me, but at least they don't accept that as being notifying the client. So I don't know what else to do on that instance. And in terms of whether I had taken courses to correct actions of managing the account. I did that at, during this whole period where they were inundating me with letters and complaints. And I've told them that, showed them, actually submitted it to Bar Council, the copy of classes that I've taken. For her to say that she wasn't aware of that, maybe her recollection, because she's doing so much, she don't remember that. It's on the record. It was on the record in my appeal, and it's on the record during the testimony of the hearing that action has been taken to show that I've taken steps to make sure I don't have issue of improper calculation of accounts. I've even hired, gotten softwares that will calculate all this without me being involved in it. And that was shown to them. So her stating that nothing has been done that she's aware of, or maybe I misunderstood what she was saying, is a bit incorrect or a misstatement of facts. There are numbers of misstatement of facts in their conclusion of law. I'm not good at presenting on behalf of myself because I get emotional, but this is a target they are set on this bar me for something that I believe I didn't do wrong against the client. And I don't think that's the role that Bar Council should be taking, is to protect the public, but I have not done anything that offend this instance, all my clients in this instance. And I believe this act, even though they claim it's, because anytime they claim it's misappropriation, automatically it's disbarment, automatically it's suspension, without investigating thoroughly what actually took place. Their position is taken automatically. And I will hope that the court would look at some of the briefs that I've submitted and the supplements that I've submitted that shows their lack of investigation, I'm asking the court to reverse the decision of the board. Thank you.
Thank you, Ms. Ikekway-Kaufman. We will look at the briefs and the complete record. We appreciate your time. We appreciate Ms. Porter's time. The case will be submitted and you all may log off.
This court is now adjourned. Counsel, can you log off, please?
I'm trying to leave.
It appears she got off.